Hi, good afternoon, everyone. Thanks for joining us. We're going to get started with today's webinar. Changes to SBA's HUBZone program are here. Their impact on your business goals. We're with PilieroMazza. We hope that this is not the first time you've done one of our webinars and that you know a lot about us already. But for those of you that may not, PilieroMazza is a business law firm that serves as a strategic partner to government contractors and commercial businesses from across the U.S. We're most well known for our government contracts practice group, but there's a wide range of legal services that we provide for our clients. You see listed here on slide number 2, including False Claims Act work, mergers and acquisitions, labor and employment, corporate work. We have offices primarily here in DC, but also in Annapolis, Maryland, and Boulder, Colorado. Represent a lot of government contractors across the country. And I am Jon Williams. I'm one of the partners in our government contracts group. I do a lot with the small business programs. I'm a proud board member for the HUBZone Council. And so this topic here today is near and dear to my heart, along with my colleague, who I'm very pleased to be joined by, Katie Flood, does a lot of work with the HUBZone program as well, in addition to a myriad of other issues, GSA compliance, protests, affiliation, mentor-protege, joint ventures. Katie's practice, like mine and a lot of us in the GovCon group, really runs the gamut here at PilieroMazza. So that's a little bit about us. Now let's turn to today's topic, the HUBZone program and major rule changes. SBA for the last couple of years has been giving us some really big holiday presents at this time of year in the form of significant rule changes. HUBZone is actually not the only big rule change out of SBA. Recently, you may have heard about the change from the 3-year to 5-year calculation for small business status that goes into effect next month. They've also made some other proposals recently, from joint venture tweaks to mentor protege to a variety of issues. So they're keeping us busy at this time of year, but what's one of the things we do here is try to stay on top of the rule changes that impact the small business program, because they're so relevant for making sure that you're doing things right and getting a competitive advantage when you're putting your teams together and pursuing work and just trying to stay eligible in these important programs. So we're going to focus today on HUBZone because they have recently issued the final rule for a major overhaul of SBA's HUBZone rules. We're not going to be able to cover all of the rules because it's a significant number of rules, but we're going to cover what we think are the big ones. And we're going to try to leave some time for questions. So I see some of you are already using your chat box. So go ahead and fire away questions, and we'll answer as many as we can as we're going through the slides. And if we don't get to your question during the presentation, we'll try to follow up with you afterwards. So please don't be bashful with the questions. We're also going to make sure that everybody gets a copy of these slides when the presentation's over with. So don't worry if you missed anything. That'll go out to you after the presentation. Also, we understand that the SBA is working on an FAQs. This would be frequently asked questions on the new rules. I think it's designed to be a way to give some practical understanding to folks about how SBA is going to interpret and apply the new rules. So that's going to be super helpful when SBA comes out with the FAQs on the new rules. Let's just keep an eye out for those. I don't know if we have a timetable yet, but I know they're working on them. So we're going to be real excited to get that from SBA and help us all get a better understanding of the new rules. So with that, let's get rolling. This is the first comprehensive review of SBA's HUBZone rules in the 20 years of the program. So the program's been around, created in 97, I think first really up and running in 99. So, they've made tweaks. It's not the first time they've changed the HUBZone rules, but this is a top to bottom overhaul of the HUBZone rules. I've got it sitting here on the desk with me. I mean, it's 131 pages of rule changes and explanation from SBA on why they're changing the rules. And we're going to talk about many of the really significant rule changes. But the process started last October. So this is sort of how the sausage gets made. The SBA proposed the rules last October, and then they took public comments. They actually gave the public more time to submit comments. It was a really significant rulemaking, and so there's a little bit more than usual in terms of public comment period, and then they issued the final rule on November 26th. So it goes into effect. That's the significant date there, December 26th, right after Christmas. These new rules will be in effect. So it's really important. I mean, one of the big things that we want you to take away from this webinar is, if you're in the HUBZone program or you are thinking of going into the HUBZone program, it's a good idea to put at the top of your radar for next year, how do you need to adjust your compliance strategies for the HUBZone program based on the new rules? Because they have made some significant changes. So some of the things that you were doing previously may not work quite as well, or may not make as much sense, or you may just need to implement some new strategies around the new rules. And that's really what we want you to focus on. All right, I'm going to turn it over to Katie to talk to you about why did we do these rule changes.
Thanks, John. And as John mentioned, the proposed rule came out last year, but this has been on SBA's to-do list for quite some time. It's always showed up as on their annual Federal Register update. So this has been in the making for a while. And the reason why is because SBA recognized that in order to stay compliant with the requirements of the program, there was a lot of ambiguities in the current rules, and there was a lot of compliance challenges. So SBA realized that was scaring off a lot of not only potential HUBZone small businesses, but also the federal contracting agency, contracting officers, to feel comfortable with setting aside a contract for the HUBZone program, to feel comfortable with that they're going to get qualified and responsive bids from HUBZone companies that could stay compliant with the program. So for examples of that, I don't know if you like, if we have some HUBZone companies on the webinar today, but for example, having to work 40 hours in a month. What is the definition of a month? So those are the types of issues that SBA was trying to address in these new rules to make it more clear. So also too, one big issue is that part of the HUBZone compliance and eligibility was having your principal office located in a HUBZone and having 35% eligible HUBZone employees. And underpinning that understanding is, what is a HUBZone? And that definition of a HUBZone is constantly shifting, or what constitutes an eligible HUBZone. So SBA was trying to address that issue and essentially make it easier for companies to stay within a HUBZone.
Yeah, I think that's really one of the key takeaways, is that SBA is trying to make the rules more user-friendly. And I think we really applaud SBA for those efforts. The HUBZone program rules have always been one of the most confusing and difficult rules for small businesses and for advisors like us to keep up with and to implement. So any steps that can be made towards making it more user-friendly, that's good for HUBZone firms, that's good for agencies that want to award HUBZone contracts. It's good for the HUBZone program in general. We've got to get the HUBZone spending back up in the right direction. It's for many years been going in the wrong direction. Government is far away from meeting their HUBZone goal compared to how they're doing for other small business programs. So we really applaud SBA, and especially for doing it so quickly. I mean, this is a massive overhaul of the rules, and it really took them just about a year to get that done. So I think it's really great, and the reasoning behind the rules makes a lot of sense to us. So here's a quick overview, and we're going to drill down on all of this, but these are the key changes in the rules. So there's no more requirement to be eligible on the bid and award date for each HUBZone contract. Instead, what they're doing is they're instituting an annual recertification. And we're going to talk about that, so I'm not going to delve into it on this slide, but we're going to get in depth on each of these. The employees can continue to qualify as HUBZone employees even when they no longer live in a HUBZone if you meet certain requirements, which we're going to talk about. That's huge. HUBZone employees have to reside in a HUBZone for at least 180 days prior to the certification date. That's not necessarily a new rule. The SBA always wanted to see 6 months, but they used to give you more flexibility. And we're a little disappointed that under the new rules, there doesn't seem to be wiggle room anymore. If you don't meet the 180 days prior to the certification date, you can't count that person as a HUBZone employee. At least that's how we're reading the rule. Maybe we'll see when the SBA comes out with the FAQs, there's more flexibility than we realize, but that seems like a significant change as well. They put another big change in this final rule that actually wasn't part of the proposed rule, that you can have your principal office continue to qualify as HUBZone for at least 10 years, even if the area loses HUBZone status, as long as you meet certain requirements. So that's a big change too. I know the HUBZone Council were championing that change, and we really think it's going to be great for HUBZone firms.
So really quickly, we're going to try to walk through some of the amendments to the definitions that are important to the HUBZone program. And the first one that's important is attempt to maintain compliance. It was never really clear in the current version of the rules how low essentially is too low with regard to your HUBZone employee percentage. And so SBA decided that for certified firms with current HUBZone contracts, that there's going to be a floor for your HUBZone employees percentage, and that would be 20%. So as long as you stay above 20% during performance of a HUBZone contract, and that you're making efforts to hire more HUBZone employees, you can maintain that compliance. But if you fall below the 20%, SBA is making very clear that that they can decertify you from the program as a result of falling below that number. They're also making clear that if you fall below 20%, you have an obligation to notify them, SBA, that you've fallen below that number, so that they can either initiate decertification or do an eligibility examination. So this attempt to maintain compliance has always been known as the safe harbor provision for companies that have current HUBZone contracts. So you can't use this 20% floor to be recertified if you don't have any current HUBZone contracts.
Yeah, I think that last point's really clear. This gets confused a lot. You can't qualify under the attempt to maintain compliance threshold if you're not performing on a HUBZone contract. And that's going to be a HUBZone Prime contract. There's nothing in the rules that we've seen that would allow, somebody's asking a question here, for that to apply to a subcontract. It's got to be a HUBZone contract. You've got to be at 35% when you first get into the program, your initial certification date, and you've got to continue to be at 35% for your subsequent certification dates, unless you start performing on a HUBZone contract, at which point your percentage goes down to 20%. We're going to spend the next few slides on the definition of employee, because this is such a critical definition for the HUBZone program, and they did make some important tweaks to it. But one thing they didn't change is the requirement that to be considered an employee, an individual has to work at least 40 hours per month. They had considered changing that to 20 hours per week, but they changed it. They decided not to change it because they got a lot of negative pushback on that, and SBA ultimately agreed that this wouldn't be good for HUBZone firms and their attempts to hire and retain HUBZone employees. So we're sticking with the 40 hours per month, and I think that's a good thing. To determine employee status, and this goes back to one of the ambiguities that Katie mentioned that they're trying to clean up, the rules make clear that they're going to look at your payroll records for the 4-week period immediately prior to the relevant certification date. So whether it's your initial application date or it's your annual recertification date, they're going to look at the 4-week period immediately prior to that date. They also had considered making some other changes, but decided not to make changes, which we think are good. So there's still going to be a broad ability to count temporary and leased employees or individuals that you get through a union agreement or through a professional employer organization. As long as they otherwise meet the definition of employee, they'll continue to count as employees. Compensation is really the critical part about having employees. You know, the intent of this program is to get economic benefits into historically underserved areas. So obviously, like, one of the real key ways to do that is to get compensation to the employees who are living in those areas. And so if an individual does not receive compensation, such as a volunteer or someone that receives deferred compensation, they're not going to count as an employee. There has to be a present economic benefit. Now, the SBA has said in the new rule that in-kind compensation, like if you give an employee food and housing in exchange for the work they're performing, that could count as a present economic value, as long as there's a demonstrable financial value to the individual and it's compliant with relevant laws. And they suggested that you need to have an agreement with the employee to really make sure that this is all clear. So if you have any in-kind compensation arrangements with your people under these new rules, we need to look at putting an agreement in place and making sure that we're complying with the new rules. Another important change pertains to owners. Owners who work at least 40 hours per month are going to be considered employees, even if they're not compensated. And they said if a sole owner works less than 40 hours during the relevant 4-week period, but if they have not hired someone else to direct the company, then the SBA is going to treat the sole owner as an employee. So I think some of this is just clarification, some of it's new. But the bottom line is, I think they're going to focus more on counting owners. So if you are an owner, and particularly if you are the only owner of your business, you need to think about whether you're going to be counted. Most likely you will be if you meet these requirements. And then, how does that impact your compliance going forward? 1099s, there's a lot of hand-wringing over 1099s, but so SBA is trying to clear up some of that here, and they're saying that 1099s generally are not going to be considered employees for HUBZone purposes. That said, SBA has what's called the size policy statement number 1. It's a policy statement they issued. It's probably like 30 plus years ago. It's been around.
86.
Yeah, it's been around for a while. And this document has a series of factors, 10, 11, 12 factors, something like that, that SBA uses to determine who is the employer of an individual. So we've listed on this slide some of the key questions that SBA asks in determining who the employer is. And so and you would be considered the employer of an individual under these size policy statement factors, then that individual will also be considered an employee for HUBZone purposes. So they don't want to have sort of conflicting outcomes where for HUBZone purposes, the 1099 is not an employee, but for size purposes under this policy statement number 1, they are an employee. So if they're an employee for one, they're an employee for all purposes. And I think that makes a lot of sense. SBA is also going to allow firms to obtain HUBZone employees from, there are companies out there, I guess, that they're in the business of providing HUBZone employees, and they might provide the same HUBZone employees to multiple different companies. The employee works 10 hours for this company, then 10 hours for that company, then 10 hours for the third company. And as long as these arrangements are above board, arm's length arrangement, there's no like subterfuge or other, problematic aspects of it, SBA says that they're okay. Next definition is the definition of principal office. The other critical eligibility requirement besides your employees is where your principal office is located. There's not any change to the job site exception, which is a critical exception for companies in the construction and services industries, that if you have employees who work on a job site, they don't count towards determining your principal office. SBA is only going to look at the employees who work out of an office. They're not going to look at employees who work on job sites when they determine your principal office location. So that's how it's always worked. They're not changing that. They are clarifying that this job site exclusion, as we call it, applies to construction and services industries. They've added something explicit in the rules, which has always been a requirement, but it just hasn't been explicit in the rules, that you have to demonstrate you conduct business at the principal office location. You can't just simply own or lease the building and then call it your principal office location. You have to actually be conducting business there, but they don't require a specific type of business to be conducted there. You just have to be conducting business at your principal office location.
Right, it doesn't need to be the headquarters for the company.
It does not need to be the headquarters. That's a good point. So, and in fact, the SBA has said in the past that they want to encourage firms that have their headquarters in a non-hub zone location to open another office in a hub zone to try to take advantage of the HUBZone program and to help that hub zone area. So you don't have to move your headquarters into a hub zone. You just have to employ the most amount of people who work in an office have to work in your HUBZone principal office. Again, we don't count job site employees if you're in construction or services. One issue that comes up frequently with the principal office is when you have employees who don't work in any one location, exclusively, like they might go to multiple, maybe they're at a job site some of the time and they're in office one some of the time, they're work from home some of the time. The new rule provides a little more clarity around how to deal with those folks, or where are they classified as working. And so the real key is that you need to determine where the person is working more than 50% of their time. So if an employee is spending more than 51% on a job site, then they are a job site employee. If they're spending more than 50% of their time working at home, then they work from home, and that's a home office situation. Or if they spend more than 50% of their time in one particular of your office locations, that's their location of work. And I think that's really important. So as we talk about some compliance tips towards the end, to really think about where are our people working, how much of their, and not just like the location, but how much time are they spending on a weekly basis at each location if they're not working from just one location. And another critical point from the rule is that if you happen to have an employee who doesn't spend 51% of their time at any location, let's say they're 30% on a job site, 30% in one office, and 40% working from home. If one of those locations is not in a hub zone, SBA is going to presume that that individual does not work in a hub zone office. So if you need that individual to help you qualify your principal office in a hub zone, they've got to spend at least 51% of their time working from your hub zone principal office.
In addition to principal office and employees, SBA has also updated the definition of reside, which John mentioned a little bit earlier. As the current definition includes a 180-day period, but it's unclear if the if that's actually required. And the SBA in the past has given a little bit of flexibility with regard to whether or not you had to live 6 months in the same location prior to being able to count as a HUBZone employee or residing in that HUBZone. So essentially, SBA is doing away with that ambiguity. So they are requiring that that HUBZone employee resides and lives in the HUBZone for 180 days prior to the certification date. Additionally, SBA also has like an order of precedence in the type of documentation that it wants to receive to prove the HUBZone eligibility. So first they want to see driver's licenses or voter registration cards, and then they'll look to deeds and leases or utility bills to support that the employee actually lives in that HUBZone location. Another key change is that you can count U.S. residents working overseas if for a particular overseas contract if the employee is paying rent or owns a home in a HUBZone. So you can continue to count them as a HUBZone employee if they move overseas in order to work on a particular contract.
Thanks. And before I flip to the next slide, I'm just going to answer a couple of questions. Trust me, we're not intentionally trying to confuse you so that you have to you have to call us for advice, although that may be the outcome,
benefit, yeah.
right? Because these are, even despite SBA's good work to clarify and simplify the rules, they are still confusing. So to go back to the principal office requirement and where you're spending most of your time. Remember, principal office is different from the 35% requirement. When we're deciding if you meet the 35% requirement, or as Katie mentioned, there's now a floor, it goes down to 20% if you're working on a HUBZone contract, that applies to all of your employees. Everyone, regardless of where they work, we're going to look at them in determining your compliance with the 20% or the 35% requirement. When we're talking about principal office, we're focused at that point on where your employees work. And the new rule really zeroes in on where are they spending at least 51% of their time. And to comply, you need to have the most people who work out of an office work from the HUBZone principal office location. People who work on a job site, we don't worry about them for the principal office location if you're in construction or if you're in services. So I hope that clears up some of the questions we got. We'll be happy to drill down with some of you that might have more questions on that topic afterwards.
And also too, just to clarify, there needs to be one HUBZone principal office. So if you have, for example, 5 people working for your company and 3 of them work from home in HUBZone residences, those would all count as separate work sites. So there would be no one HUBZone principal office.
Mm-hmm. Okay. So we're going to keep rolling. Then the HUBZone maps are still frozen. I have little kids. We're really into Frozen in my house right now, so I couldn't help the little Frozen joke here. But the final rules make clear that firms that were located in redesignated areas from December 12, 17 forward, if they went redesignated from that point forward, they're going to stay HUBZone. So the maps are basically frozen until 12/31/2021. So we've got about 2 more years of that frozen period. And the idea is that we want to get past the 2020 census so that we have a good sense based on the 2020 census of what the new maps are going to look like before we lift the freeze on those redesignated areas.
And these are just 2 quick changes to HUBZone eligibility requirements. The first is size. There was an ambiguity in the current regulations because when you apply to the HUBZone program, you have to be a small business under your primary NAICS code. That's a requirement for initial program eligibility. And then the question then becomes, if you outgrow the size standard for your primary NAICS code, are you still an eligible small business for purposes of the HUBZone program? And so SBA has eliminated that ambiguity by saying, as long as you are small in at least one of the NAICS code in which you operate, you're still eligible as a HUBZone small business. but you still need to be a small business in your primary NAICS code for purposes of program application. And then, with regard to the 35% HUBZone employee calculation, SBA had a policy of always rounding up to the nearest HUBZone employee. So for example, the one that always seemed to kill a lot of companies was if you had 6 employees, 35% of 6 employees would equal 2.1 employees. So SBA said you needed at least 3 HUBZone employees to qualify for the program, which is actually a 50% calculation. So SBA has decided that common sense math should apply. And so you'll round to the nearest whole number in order to figure out how many HUBZone employees you need to meet the 35% calculation.
Yeah, so that's another great example of just some business-friendly added flexibility that SBA put into the rules, and we think will really be helpful for HUBZone firms. So big change for the principal office eligibility. I talked about this at the outset. Now we can drill down a little bit on the significant long-term investment component of principal office eligibility. The rule says if a firm owns its principal office location or makes a long-term investment, which is a lease of at least 10 years in a HUBZone area, that principal office location will remain HUBZone eligible for no less than 10 years. That's really a fantastic change. I mean, this gives firms greater certainty than they have right now, that if you're looking to go in and invest, I've heard clients say, you know, I might go invest in this HUBZone area, but I can't justify the expense of buying an office or moving my operations if I might have the rug pulled out from under me 2 or 3 years later when that area loses HUBZone status. And I think that has discouraged a fair amount of firms from participating in the HUBZone program and locating in HUBZone areas. So we're really positive about this change here, and the SBA's recognition, you know, that you shouldn't be forced to move just because the HUBZone location that you originally went to has lost its HUBZone status, because you should actually get patted on the back for that. You were a part of helping that area to lose its HUBZone status because you located there, and that helped to improve the economic climate in that area. So there are some caveats on this new rule, and keep in mind this was not in the proposed rule. They added this in the final rule, so we don't have the FAQs from SBA yet, and I'm hopeful that we'll get some FAQs around this to make sure we all understand it. But the new rule says that this applies at the time of initial HUBZone certification. So it's not clear if it's going to apply retroactively to firms that have already gotten into the HUBZone program. So in other words, they already had their initial HUBZone certification. And it's also not clear if it's going to apply to a significant long-term investment that you might make for the first time prior to an annual recertification. So we just don't know the answers. So I see several questions here from folks. I mean, those are very good questions, and we have the same question. I'll tell you how I think it should work, and I think it's written in a way that would allow SBA to apply it retroactively, because it says you have to make this significant long-term investment at the time of the initial certification. Well, if when you were certified 4 years ago, you had bought your building or you had signed a 10-year lease, I think you should be eligible to take advantage of this for 10 years after your initial certification date. But we're going to have to wait and see if SBA agrees with that. I feel the same way about the annual recertification. We should encourage folks. So let's say that they have to move prior to an annual recertification because after the maps are unfrozen, you know, their area loses HUBZone status. So they move before their next annual certification. And when they move, they sign a 10-year lease. I think they should get the benefit of this new rule at that point. And I hope that SBA will clarify that in the FAQs. But the rule does say initial HUBZone certification. So, you know, that's not clear. The rule also says this won't apply to subleases and it won't apply to shared office space. The SBA doesn't think that virtual offices or co-working arrangements rise to the level of being a significant investment. So if that's what your lease is for, it's not going to count. It needs to be, I guess, a separate exclusive office space that you are leasing for at least 10 years directly from the landlord, not subleasing, or that you bought. Also, some big changes that we're going to drill down on. We've talked about them in the definition section on counting HUBZone employees, and there have been a number of questions around the 180-day requirement. So here's what the new rule says for this is the ability to, I'm calling it sort of permanent HUBZone employee, that if you can continue counting this person as a HUBZone employee as long as they continue working for you, even if they stop working in a HUBZone, stop living in a HUBZone, excuse me. So they're a permanent HUBZone employee as far as your HUBZone eligibility is concerned, as long as they meet these 3 requirements on the screen here. They have to live in a HUBZone for at least 180 days prior to your initial or your annual certification date. They have to live in a HUBZone for at least 180 days after that certification date. And they have to continuously work for your company. So, and this is going to apply retroactively. So any of your current employees that meet the test, all 3 requirements, if you have the supporting documentation, they'll count.
There's a few caveats. If there's any break in the employee's employment with the HUBZone firm, the employee would have to requalify as a HUBZone employee according to those 3 criteria that John just walked through. So that's an important caveat. In addition, the HUBZone firm must maintain records of the employee's original address and continued uninterrupted employment for the entire time the firm is in the HUBZone program. So we're going to talk about that towards the end of the presentation, that you should be tracking your HUBZone employees in a compliance file and making sure that you document their initial HUBZone eligibility with both their driver's licenses at that time and the HUBZone maps, because those would be 2 difficult things to recreate if your HUBZone eligibility is questioned at a later time.
Yeah, there's a question here about unbroken employment, like leaves of absence. You know, I don't know that the final rule really addresses things like long-term disability, where there might be someone might still be employed, but yet isn't working. They wouldn't meet the HUBZone definition of employee necessarily if they're not working, and I think that's what we should focus on. Let's look to see if we get a little more clarity around that in the FAQs. That's a good question.
The final rule, the rules that come into effect at the end of December, they also clarify SBA's policy with regard to HUBZone companies having affiliates. The current versions of the rules have always allowed HUBZone firms to have affiliates, and they say that affiliation does not necessarily impact the HUBZone concerns HUBZone status. There's always been a question of what does that mean, though. So SBA decided to drill down and provide a little bit more clarity on what the test is. So where the HUBZone firm and its affiliate are intertwined and acting as one, SBA says that they will count the employees together in determining if the HUBZone firm meets the 35% in principal office requirements. And SBA said that they're going to employ what's known as their totality of the circumstances test, which is a test that they have put in place for size size calculations too. But essentially, employees of affiliates are likely to be counted together with the HUBZone firm's employees where there's no clear line of fracture between the companies. The employees are in fact shared, or there's evidence of intentional subterfuge. And we're going to discuss what the clear line of fracture test means on the next slide, because SBA has finally provided some official guidance on what they're looking for when you establish that clear line of fracture. SBA has also provided an important point of clarification that they won't count employees of an affiliate for HUBZone purposes if those two companies would not be treated as affiliates for size purposes. And that becomes important for tribally owned or entity owned companies, where they might have sister companies that share a number of common ownership and back resources, but they're not considered quote unquote affiliates for size purposes.
Yeah, and before Katie moves on, I want to go back to the employee issue because we're getting deluged with questions here on this. So let me just take a few of these questions. So there's been a number of questions about, all right, so if it's retroactive, how far back does it go? Well, there's nothing in the regs that say it only goes back a certain number of years. It can apply to someone that was in the program. I see the question here 5 years ago, as long as you can demonstrate you met these requirements. But it says at the annual certification date or initial certification. So that's what the new rule is. If we're going to apply it retroactively, I don't think it's going to apply to any dates other than your initial HUBZone certification date, and then you get recertified every 3 years under the current rules. Some people are asking, well, what about when we do our annual SAM update? Or what about when we certify on a HUBZone contract? I don't think that's going to count. I think it's going to have to be who was your HUBZone employees as of your initial certification date and your 3-year recertification dates. And if those people lived in a HUBZone 180 days before and 180 days after, and they continuously worked for you, and you can document all this, then I think you have the ability to take advantage of this new rule and consider that person to be a quote unquote permanent HUBZone employee as long as they continue working for you. But there can't be a break in the employment. So there's been some questions about what about, like, for example, construction, where there might be seasonal employees. They're not going to count. If you have a seasonal workforce, the seasonal workers will never qualify for the quote unquote permanent HUBZone status. And again, that's my word that I've come up with, permanent HUBZone status. That's not what SBA is calling it, but essentially that you will always be able to treat these people as HUBZone employees. That's not going to work if they're seasonal and there's a break in the employment. There's a question about the certification dates. So currently, under what is about to become the old rules, you recertify your HUBZone status every 3 years. Under the new rules, you're going to get recertified once a year, but you're still going to also go through a full document review every 3 years. So, but previous to now, there has only been a 3-year recertification. It was not an annual recertification. That's a new requirement. Okay, let's go to clear line of fracture, Katie.
Well, just really quickly, with regard to affiliation, SBA says there won't be affiliation, or there won't essentially combine the employees of your affiliate companies if you can demonstrate that the two companies maintain a clear line of fracture. So they finally provided some clarity with regard to that standard, which has always been the standard, but now it's official. So things like operating in the same or similar line of businesses, same geographic location, if you're in the same NAICS code, an industry essentially is what they're looking for. You're sharing office space, equipment, employees, your logos are essentially the same. with websites and email addresses. All of the points listed on this slide essentially will go towards proving whether or not there's a real, true, clear line of fracture between the two affiliates. So SBA won't essentially merge the employees together in determining what the HUBZone firm principal office and employee count is. SBA also provided a little additional clarification, like I said, for parent, sister, subsidiary entities. So firms owned by, like, let's say a tribe have a common tribal parent, essentially will have often a lot of back office support that is provided across the sister companies. And SBA is clarifying that minimal business activity between affiliates will not result in a combining of employees, such as using common back office support or administrative services. And I think this would apply too for even non-tribal or non-entity owned companies. For example, if you're running all your payroll through the same QuickBooks application for both companies that you own, I think that's the type of thing, or you're using the same accounting company to do your record keeping for your two companies. That's the type, SBA is saying that that type of back office support won't rise to an affiliate or a lack of clear fracture between the two companies.
Yeah, I think that's an important clarification, because otherwise the new rule that they put in place back in May 2018 wouldn't really be that helpful, that you're allowed to have a parent company owning a HUBZone firm, but yet the parent company can't provide common back office or administrative services without causing an affiliation. That'd be a real issue. So I'm glad the SBA provided this clarification. Before I jump to I'll go ahead and jump to the next slide, but before I start talking about it, we've had several questions about virtual office spaces like WeWorks, because on an earlier slide, I mentioned that SBA says virtual office spaces won't count. When I mentioned SBA's new rule on virtual office space, that's only in connection with this 10-year significant investment rule. So in other words, if you're going to say that you want your principal office to count for 10 years as a HUBZone principal office because you made a significant investment, you bought your office or you had a 10-year lease, it can't be with WeWorks or another place like that. That won't count. Now you can have your principal office at WeWorks in a HUBZone, but if the WeWorks location loses its HUBZone status, then it can't be your principal office anymore. You're not going to get this 10-year significant investment exception that will let you keep using that office as a HUBZone location even after it's left the HUBZone program. So I hope that's clear. If anybody on here that is in a WeWorks or virtual office location wants to follow up with us directly afterwards, we'll be happy to address your situation specifically. I didn't mean to create any confusion that you can continue using shared office locations as long as it meets the requirements of the program. You're just not going to be eligible for this 10-year significant investment new rule that they just put in place. Initial certification process, they're going to try to start banging them out within 60 days. I'd say that will remain to be seen if they can hit that, but it's certainly a good objective that they're supposed to, under law, be aiming for that mark. The SBA has put a little more into the regs to make it clear that you have to immediately notify them if there's any changes that affect a pending application. They also want to make sure that the right people, owners or officers, are making the representations in the the application. And they had proposed to allow a reconsideration if you disagreed with the denial of your application, that you would have 90 days, or you would have a period to ask for reconsideration. But they did away with that. They didn't finalize that proposal because they decided it really wasn't worth it to give you reconsideration because you're already allowed to submit a new application within 90 days. Now, what's interesting though is they did away with the reconsideration, but they said that if you're found to be ineligible in your application, you have 30 days to provide documentation showing you are in fact eligible, which kind of seems like a reconsideration request to me. So maybe there is still some type of reconsideration request. We're getting some questions about Katie's slide on minimal business activities and back office functions. We've given you everything that the rules provide on those, so we're going to have to wait for SBA FAQs to see if they might flesh out a little bit more. What do they mean by minimal, and what do they mean by common back office or administrative services beyond what we included on the prior slide? We've talked about the annual recertification change, but here's an opportunity on slide 26 to drill down on it a little bit more. So like I was saying in answering some of the questions before, the current rule, which is about to become the old rule, says that you have to be HUBZone eligible on the bid and award dates for every HUBZone contract you pursue. And it also requires that every 3 years you go through a recertification of your HUBZone status. Under the new rule, there's going to be an annual recertification. So not every 3 years, every year. But important is that you will not have to do a full document review every year. So the annual review is going to be like a check the box self-certification. There haven't been any changes in my eligibility over the last year. SBA has the right to come in and inspect you if they have a reason to question your annual certification, but you're not going to have to provide them copies of your payroll records and all that stuff for your annual recertification. You will have to go through a full document review every 3 years, but not for your annual recertification. And the real significant change here is that your annual certification means you're eligible to bid on and win any HUBZone contracts throughout the upcoming year. So you do not have to be HUBZone eligible on the bid and award dates during that upcoming year. If you're eligible on your annual certification date, you're eligible to bid on HUBZone contracts for the next year. Now, when you bid on those contracts, you are making a HUBZone certification, but you're certifying that you were eligible on your most recent annual renewal. So you don't have to be eligible. You could fall out of HUBZone compliance. You could go through a merger or acquisition, or just decide leave the HUBZone program, and you could still bid. You have to provide a notice to the SBA, and some that might impact what you can do from that point forward. But the annual certification is what matters, and that's really the significant change here. So a little bit more on the annual certification. So Katie mentioned the floor of 20%. So this is really important too. When you're going through your annual certification, you have to be at 35% for your HUBZone residency requirement, unless you are performing a HUBZone contract. And if you're performing on a HUBZone contract, then you remain eligible as long as you're hitting 20%. So that will allow you to remain in the program, and you can go through your annual certification, thumbs up, you pass, continue for another year at 20% if you're performing on a HUBZone contract at that time. If you have no HUBZone contracts, you've got to be at 35%. And then you also have the ability to, for employees that you add during a program year, they could qualify for this what I call permanent HUBZone employee status if they work for you at least 180 days before your next annual certification and 180 days after your next annual certification, and and they continuously work for you. There's no gap in their employment. So I did mention about mergers and acquisitions. The new rules require you to notify SBA if you merge with another business or you fail to attempt to maintain the minimum HUBZone residency requirements, and they have the right to decertify you from the program based on that. So whenever you go through a merger or acquisition, you've got to think about what is the impact of that transaction on your HUBZone status. If there's a protest against you, or if you're going to file a protest against one of your competitors on a HUBZone contract, just know that your allegations are going to be based on HUBZone eligibility as of their most recent annual certification date. That's what you have to allege. At the last time they went through their annual certification, they weren't eligible. And when we were looking at the rules, we do a lot of joint ventures here. Very popular for the small business programs, and especially for HUBZone the last couple of years since the JV rules got more friendly. So I was wondering, how does this annual recertification requirement apply to HUBZone joint ventures? Katie, do the rules address that?
So this is going to be part of what you certify in your compliance as part of the HUBZone joint venture when you submit the offer for a HUBZone joint venture. Essentially, you're certifying that the HUBZone partner to the joint venture has met the SBA's certification requirements either in its initial application to the program, certification to the program, or its annual recertification. The new rule also kind of clarified SBA's position with regard to HUBZone set-aside IDIQs. So essentially, how does your HUBZone eligibility work when you are issued a multiple award IDIQ contract, and multiple task orders will be issued under there. And the main changes really come to are about the 20% HUBZone floor. So essentially, that initial MAC qualifies as a HUBZone contract. So the rules clarify that the firm must maintain at least the 20% HUBZone employee floor for the entire life of that contract. With regard to specific task orders, if you're eligible HUBZone at the time of getting the contract, you're eligible for all task orders, even if you end up being decertified later and some of those task orders are issued after you are decertified from the program. This, of course, there's always the caveat unless the contracting officer explicitly requires HUBZone recertification in connection with that particular task order. There's also a question on non-HUBZone set-aside IDIQs. The best example I think of a multiple IDIQ that's not set aside for a particular program would be for the federal supply schedule, for example. And SBA has decided to carve out task orders that are awarded under the federal supply schedule for purposes of your meeting HUBZone eligibility. Essentially, it's going to work like a HUBZone set-aside IDIQ, whereas if you were eligible at the time you were awarded the schedule, you're going to be eligible for each individual task order issued under the schedule. So that's a good clarification. Otherwise, if you're working on a non-HUBZone set-aside IDIQ contract and HUBZone set-aside task orders are issued thereunder, you have to meet the eligibility requirement at the time the task order is issued and maintain 20% HUBZone employees for the period of that task order.
Thanks, Katie. Katie does a lot of work with IDIQs and recertifications, GSA. So this is a very confusing area for folks. I see we have a number of questions here. I would suggest, especially because we're almost out of time here, that you follow up directly with Katie. And if you submitted a question, we will get back to you afterwards if we didn't answer it. We just want to wrap up with some quick compliance tips. And thank you all so much for hanging in. I know this was dense and sort of a lightning round run through and there's a lot of rules that we didn't even get to touch on. So like we said at the outset, this is a comprehensive overhaul of all the rules. And so some of the tips that we have here are probably things you're already doing if you're in the HUBZone program, but especially under the new rules, it's going to be critical to make sure you have a good compliance file for all your HUBZone employees. Because especially if you're going to take advantage of what I keep calling the permanent HUBZone status, the rules say you have to maintain records on that company's employment back to when they first started working for you. So we've got to make sure we have a good file on every HUBZone employee. And you're going to need to know, when did your HUBZone employees first start living in a HUBZone? With this 180-day requirement, which has always been in the rules, but like I said, I think there's no flexibility there now. I think they don't count unless they've worked for you for 180 days prior to your certification date. So we need to know, when did each employee that lives in a HUBZone start living in the HUBZone? I think it's worthwhile to look at long-term investment options in qualified HUBZone areas, given this 10-year certainty that the new rule would give you. We need to wait for the FAQs to see if that'll work for your annual recertification, or if this is only for initial certifications. Hopefully it'll apply to annual certifications, not just initial, but we'll have to see. If you have multiple offices and or job sites, then you need to have a compliance strategy that allows you to track where people are spending their time. And if you have people that are not spending at least 51% of their time at any one location, how does that impact your HUBZone eligibility? You need to plan far enough in advance of your annual certification dates, especially because of this 180-day requirement. And I agree with the gentleman that just submitted a comment about the 180-day rule being onerous. We're really disappointed by that. We did so much good work in these rules to make them more flexible and easy for HUBZone firms and more attractive to agencies, but this one is onerous. And so, as you approach your annual certification date, because you need HUBZone employees to be working for you for 180 days before that date, if they haven't already qualified for you, if it's a new HUBZone hire that you make during the year, if it's past the 6-month mark of the year, that person won't count. So you've got to be planning far enough in advance. And then we want you to think about the impact of HUBZone status before mergers and acquisitions. And of course, we want you to call us if we can be helpful. We live and breathe this stuff, and big fans, proponents of the HUBZone program. Appreciate all the good work that SBA did on these rules and all the good work all you HUBZone firms are doing out there. So thanks for your time. We will get back to all the questioners that we weren't able to answer. There were a lot of them. Thank you for sending them in, and hope to talk to y'all or see you on another webinar soon. Thanks. Bye.